We have this funny split profession in England, so you get two lawyers for the price of one, solicitor and a barrister. I specialize in sports law, doing a lot of work in football, and I think I've been involved in all the third-party ownership cases that we've had in England over the past 14 or so years, going back to the Tevez case. And I also wrote the book with a number of others, including Daniel, Football and the Law, where in the chapter on third-party ownership we discuss those cases.
Thank you, Nick. So, yeah, this is the traditional English split. The barrister ends up speaking more and the solicitor talks on some matters. But the truth is it's an honor and a privilege to be speaking at this event with an esteemed colleague like Nick as well. Our aim over the next 45 minutes to an hour or so is to take you through some of the updates, what actually has happened over the last few years, and then in a way to speak about the practicalities that myself and Nick have seen maybe over the summer months and the summer window for understanding and establishing the new evolution of third-party ownership, third-party investment. And by way of brief background, I am a lawyer at Sheridan's. I primarily focus on football-related matters, and I tend to work with players and agents. And one of the themes running throughout a little later of the session will be talking about, in my view, why players have very interesting opportunities with the new tweak to the regulations, but actually how there are some significant risks also involved.
Okay. So you can see in the title we've said where we are and where we are going in terms of third-party ownership. So perhaps the first part of this will be relatively brief because I'm sure many of you know this, but just to take you through the landscape in terms of what third-party ownership is and to give it a very brief definition. The one I use is just this, because I think it's useful to focus on the fact it's a financial interest. So any financial interest in the future transfer of a player's registration. And the obvious example that most of us are familiar with is some kind of loan agreement given to a club in respect to a future transfer of a player. And it's important to distinguish between two things. One is third-party influence, which has obviously been banned by FIFA and most of the national federations for many years. And I don't know anybody seriously in football who disputes that ban. Third-party influence, it goes back to 18 bis of the regulations, which say that no club shall enter into a contract which enables the counter club or any third party to acquire the ability to influence employment transfer related matters. And that is obviously banned because of, amongst other things, the real danger to the integrity of football that you have if a third party can influence transfers, as they have done in some of the leading cases. Certainly in England, the Tevez case was a problem. So that rule has been there for many years. The rule that came in the regulation in 2015 was 18 ter, and that's a different regulation because what that bans is third-party ownership or third-party interest, which is perhaps a more scientific term for the same thing, prohibits that outright. No club or player shall enter into an agreement with a third party whereby the third party is entitled to participate in full or in part in compensation payable in relation to a future transfer. It's an important distinction because that ban, as many of you know, is much more controversial. The fact that there may be a financial interest in a future transfer can have benefits. And so there are many in football, and we'll go on to this at the end of the discussion, who think it's not a bad thing to have third-party ownership, but it's something that ought to be regulated. So that's the important distinction. And just to start off, there's been some argument since 2015. Many of us argued that the outright ban on third-party ownership was disproportionate and anti-competitive. That's been tested to a certain extent. And I think it's fair to say, if you asked a lawyer now what's the legal position, that it would be difficult to persuade a court that FIFA's ban is unlawful. Most particularly because of the Seraing case, where you're probably all familiar with this case. It's a very important case for other reasons as well, in particular about what it said about arbitration. But in a nutshell, in that case, so far as it concerns third-party ownership, in the case, FIFA argued that it was a proportionate restriction in support of those following four, do you see at the bottom, legitimate objectives. And I think it's important to focus on those legitimate objectives. These are the reasons FIFA argued successfully before the CAS in that case that the ban on third-party ownership in 18 Ter was lawful. So the legitimate objectives are contractual stability. You want to prevent third parties endlessly maneuvering and manufacturing transfers in order to make money from those transfers, because that undermines contractual stability. The independence and autonomy of clubs in recruitment policy, same point in some respects. The integrity of football, preservation of loyalty and equity of competitions, and the prevention of conflicts of interests and securing transparency in transfers. So those are the objectives. And as I say, it's important to have those in mind, because if you consider the argument we'll come on to later, whether third-party ownership ought to perhaps be allowed but regulated, clearly what you must come up with is an argument that allows for effective regulation, still protecting those legitimate objectives. But in short, in the CAS case in Seraing, the CAS were persuaded by FIFA that the ban was legitimate because it was a proportionate measure in favor of those objectives. Now, the story is not completely over, because as you probably know, that case then went on. Doyen took that case to various other jurisdictions. I know Melanie is going to speak a little later on about what happened in the Swiss Federal Tribunal, but it also went to the Belgian Court of Appeal, where an important decision came up and found that it was justiciable that they could go behind the arbitration clause in FIFA, which is why it's an important decision on that point itself. But the substantive appeal, in terms of whether it's anti-competitive or not, under EU law, has not yet been determined. I understand will be determined very, very soon.
And I think
something on that, didn't you?
Yeah, exactly. But I'll probably tell people in private later rather than to everybody. But I think the interesting bit that Nick mentions here as well is from reading the review of the judgment, and obviously the judgment you have so far, the CAS judgment wasn't in English. I don't think anybody substantively argues with the objectives of the ban. The query is on proportionality grounds. And without looking in too much detail in the judgment, maybe one of the deficiencies of some of the arguments raised was that perhaps the economic analysis and the particular significance there as to the proportionality arguments could be maybe fleshed out in some more detail. And I think this leads on to another interesting debate and discussion, which we more or less had yesterday as well, which centered around, for example, the contentious capping issue for agents' commission. And I think it is likely from the variety of reports we have seen that if there is to be a legal challenge, my view, and I'm sure Nick's view may have some thoughts on that as well, is that one of the substantive grounds that is going to be, I think, a minefield for arguments is going to be on the proportionality arguments. And I think in addition to that, the interesting element, I believe, with the CAS judgment is, as much as they are ruling on EU law, no EU court, the Court of Justice, or the Commission has taken a forthright, formal view on that. And that is not discounting for 1 second the expertise of the CAS, but I think depending on how that agents commission cap dispute evolves, that might be a next interesting point to bear in mind, which is the European court dimension to a European competition law issue.
Yes, I think Daniel makes a very good point. And going back to that interesting discussion that Ulrich gave us yesterday about predictive analytics in arbitration, sports arbitration, it would be wrong, in my view, to conclude from the Seraing case that arguments about competition law and EU law and third-party ownership are dead, are finished. They are not finished. This is a current state of proceedings, but it may well be and I think one sees it to a certain extent in the decision in Seraing, it's reflected there, that one of the problems was maybe the way that case was presented, maybe the way that case was argued, and the fact that insufficient evidence was provided to reach the quite high burden that it was anti-competitive. And so if another case is brought and argued in a different way, it doesn't follow that the same result would necessarily occur. And as Daniel says, proportionality is the key in this and in the agents caps issues. So that's where we are in terms of the legal position now. The other important update is this new amendment that took place since the June 19 edition of the RSTP, by which FIFA clarified something which was uncertain, and that is that players are not a third party. It kind of sounds obvious, and certainly my view had always been players can't be a third party, but it wasn't clear in the previous regulations. You can see the previous definition of third party in definition 14 of the RSTP was a party other than the two clubs transferring a player. And so read literally, a player would be a third party under that definition because it's a party other than the two clubs. So it's now been clarified with that amendment, a party other than the player being transferred, the two clubs transferring, etc. So it is now clear that the player being transferred is not a third party. That is a very important development, and there are a number of consequences and potential consequences which arise from it, which have yet to be fully tested. For example, if you're a football club and you're trying to minimize the wages that you pay to players, and you have a young player who believes they are a prospect for the future, you may be interested in negotiating hard with them, their wages down, in return for them having a substantial slice of a future transfer fee. Because in the short term, at least, that would be to the advantage of the club's cash flow situation. On the other side, if you are a player and you think that you will go for a substantial transfer fee in the future, you will be keen to insert in any employment contract with a club the highest percentage you can obtain from that fee, and you may be prepared to reduce your wages if you think it's going to be a particularly high fee. So those are obvious, immediate matters that will take place in negotiation of player contracts as a result of this change. But there are other more substantial issues, some of which Daniel will come on to in a moment, so I'm not going to go into detail, but the obvious ones about the dangers of players thinking, I've got 20% of a potential fee, I think maybe £2 million or euros in the future. I want to be able to use that 20%, that contractual entitlement I have, in order to get some money now. Of course, if the player does that, they would be in breach of the rules because they would be effectively creating a third-party interest in their future transfer value with whoever they had borrowed the money from. But that's a real risk. The thing I'm particularly interested in is the situation for agents, because, of course, it's not the players who are going to negotiate these contracts, particularly if you're talking about players who are likely to have a substantial transfer fee. It is their agents. And I think there's a real danger here of conflicts arising, because if you are an agent in this situation, you are not entitled to have any percentage of that future transfer fee. You're not entitled under the current regulations, and I'm certain that whatever the new agents regulations FIFA brings in will use similar terminology in order to prevent this. Under the current regulations, it makes clear that this is regulation 7.1 of the FIFA regulations on intermediaries. The amount of remuneration due to an intermediary who has been engaged to act on a player's behalf shall be calculated on the basis of the player's basic gross income. That cannot include a future contractual entitlement, which is not guaranteed, which is uncertain, to a transfer fee or to a percentage of a transfer fee. So an agent is not entitled to any of that payment, but the agent is the person who will be negotiating whether or not that clause is in a contract or not, and whether or not, as a result of that clause being in a contract or not, the player's wage is higher or lower. That, to me, creates an inevitable conflict of interest between the agent and the player, and if perhaps not so where the agent's acting for the club, because the agent can get a percentage of a transfer fee, but that will be perhaps a hornet's nest in the future as a result of this. And that, taken with the cap that's being proposed on agents' fees, which I'll return to later on in this discussion, it also creates the danger and the risk that some agents will move towards hidden, secret deals with players, whereby they are getting percentages of future fees. So, moving over to Daniel now on some of those issues.
Yeah, thank you for that fantastic overview and discussion of what I think are some of the current topics. And I think what I wanted to try and do for maybe just 5 or 6 minutes is just to try and do two things to put things in context. The first is to provide a little bit more meat on the bone in terms of what are obviously the opportunities for players and what can be the risks for players. And then within that, actually just to talk about some of my practical experiences over the summer of working on a number of transfers and actually seeing this firsthand. So I think if we look to the positive and the opportunities, obviously there is significant upside now for players to be able to have a future right to their transfer fee. That seems pretty clear now. What that number is a question for another day. What that also potentially does, and I know we've had this issue on the flip side with third-party investment, where there is always an incentive on the owning company to try and move the player on potentially. The truth is that there must be some concern from clubs having deals that this types of clause incentivizes players to move for significant monies and may actually cause more contractual instability, because they know if a big transfer comes in and they're entitled to 10, 20, 30% of that transfer, that might cause a problem for stability within the club, within the squad, within the management team generally. All of that taken to one side for a second and talking about some of my practical experience as well in the summer, the truth is that for a number of deals that I worked on, actually at the outset, a lot of agents were not actually aware of this change to the regulations, is the truth. So sometimes the discussions that I were having with agents was when lawyers come in relatively late on in the commercial negotiation stage, to be fair, was actually to say to them, have you thought about this as a negotiating tool, as a negotiating strategy, for exactly the reason that Nick said, which was, well, perhaps there is a playoff between your current pay, bonus structure, loyalty and incentives, and actually knowing that if you're a 21, 22-year-old player at an elite club, maybe breaking into the first team, playing in a top 5 league and Champions League or Europa League, if you have 1 or 2 good seasons and you have up to 20 or 30% of your own effectively economic rights, that is a hugely significant number which you can potentially gain and benefit from. And that's nothing to do with the tax implications of actually that occurring. But I think the important thing that I wanted to also stress and touch on now is actually the vulnerability of players. And this is the thing that I'd like to just spend a couple of minutes on, because my view now is that this is obviously will be a hugely growing trend. There's no reason to suggest, so long as the player is in a good negotiation position, is adequately advised, and can put forward good arguments as to why he or she should be entitled to such monies. The vulnerability is clear, because under the old regulations, obviously now, or the new regulations rather, no third party apart from the club or the player can have an economic interest. But the issue now is that what is there to stop, and it won't be FIFA or the national associations doing this, I don't think, what is there to stop the player having a private agreement with a third party? That ultimately, in my mind, is the new danger with the new regulations, because will it be the third party that is disciplined? No, because at the moment, at least, they are outside of the FIFA disciplinary and national disciplinary codes. But who is inside the regulatory framework? The player. So what this evolves into a new situation, I believe, is that there is a real need, a real urgent need for significant education of players for the upside of taking their own economic rights, but very much so the downside of discussions with their agent, with third parties, with other entities who may become aware that this right is now available to them. So that was the second point I wanted to do. I also think that we haven't talked about financial fair play much, and this is obviously a very much different other area, but I think there's an interesting economic regulatory argument to all of this, which is if, for example, a club is able in the short or medium term to say, we're going to pay you less wages, we're going to pay you less bonuses, which obviously helps with the bottom line. That obviously is a cost saving for particular profit and loss and balance sheet issues from a club's financial bottom line. That obviously may assist a club in complying with domestic and supranational financial regulations. Now, the downside of that, obviously, is that when a transfer happens, they receive less of that transfer monies, which go towards then being able to make more profit from the transfer. But I think that's probably another thing to bear in mind too. The third thing, which Nick touched upon as well, which I believe is a very important element, is it is very common throughout Europe, and I know throughout parts of the world too, for the effective securitization of transfer fees. So, for example, when someone pays £80 million for a transfer, but those transfers are only in installments, for example, then that club, the recipient club, the selling club, wants to accelerate those payments. They can enter into agreements with banks, financial institutions, to be able to receive all of that money up front at a discount. So maybe instead of receiving the £80 million within 4 years, maybe they'll receive £75 million straight away, or something to that effect. The query we had with some of our deals that we worked on in the summer was whether actually the player could take advantage of that future financing and effectively piggyback off the club at the same time. Because what happens, for example, and going to the minutiae, is if the player gets sold on in the future and he is entitled to 20% of that money, but what happens if that 20% of that money is actually paid in 4 installments over 4 years? It might take him 4 years to actually receive the money that is due to him. So one query we had was whether that player would have the effective right to be able to securitize that future money. The second point that we had as well, which was hopefully we expect all clubs to be clear, open and transparent with us. But the truth is that we usually wanted to have some type of disclosure obligation so that we knew the amounts of money in the future that were being provided to the selling club so the player knew exactly what he was due. And that becomes an important element to consider as well. But I think in the round, what will become much more common and is already becoming common, especially from my perspective, and I only have visibility on the UK market, so it'd be great to hear everyone else's experiences in time, is that this effectively is a significant additional negotiation tool that agents can put forward, which may alleviate certain value-add problems, which is the player wants 100,000 and is only going to get 80,000. Well, actually, we bring the economic rights into the mix, and does that provide an extra lever to be able to find a better commercial solution? So they are some of the things that at least we've seen in the market over the last summer period.
Mm. And it made me wonder about if you're a player in a strong position economically, and you believe you will have you've already been sold for 3 million, so you believe your value is going to go up. It's important for you to have in the contract 20% or what have you of the future transfer value. You're also bound to insist, aren't you, on a release clause, saying that if there is an offer of 5-6 million or above, the player has the right to terminate the agreement. Certainly you would advise the player to have some kind of release clause of that type. And that means, surely, that the player will begin to influence the transfer because they will seek such an offer when the appropriate time comes, and they will have the ability as the player to trigger the release clause and force the club to sell, even if the club doesn't want to sell, if it's a properly worded release clause, which of course would be archetypal third-party influence. But the reason it's not third-party influence is because the player is not a third party under the new definition. So it's okay, but surely it, and the fact that, again, the reality of these things is it's the agent who will be determining these things and not the player in 99% of the cases, it must surely bring back into play all of the types of problems we saw with third-party ownership in the first place and third-party influence.
And if I just say one other thing, which I'm sure we're positive to see, is, as players roll down their contracts and the significant additional negotiation and bargaining position that implies, the likelihood of being able to use this type of right as an additional bargaining tool to potentially receive more lucrative percentages obviously increases as well. And that again actually is an interesting point where Nick mentions about the difference between the agent's role and the player's role and the agent's fiduciary duty, because presumably it is in the player's better interest if he can get a higher economic percentage amount to then sign a new deal. But actually it might be in the agent's better interest in different ways to be able to move to different, to move on a free, and that agent to be able to take a higher, the same percentage, but a much higher amount because the player's wages will be so much more significant.
Absolutely. And I think that then leads us on to where we're going, where we should be going, and maybe to make some polemical arguments, if we may, about this. So the starting point, it seems to me, is that 2015 was the year that FIFA abdicated from some fundamentally important areas of regulation in the most important commercial aspect of football, the transfer market. And the two things it did famously in 2015 were the new intermediaries regulations, which was effectively a whole-scale deregulation of the agents market, in the hope, certainly by some people who supported it, I recall at the time, in the hope that this would actually weaken agents and reduce their role in the transfer market, which is certainly not the consequence of that step, and the prohibition of third-party ownership. Those two things were done at the same time. Now, in respect to the deregulation of agents, that has already now been recognized as a major mistake. I think Emilio put it far more diplomatically than I would yesterday. I think he said it was not the best decision made by FIFA. Others would perhaps use stronger language because they're more able to do so. But it's certainly seen as and understood as a mistake. And that is why FIFA is now re-regulating agents. And just so far as that's concerned, I act for many of the big agents, and it's no secret that there is a major controversy over the 3% cap that's proposed, and that there are many people who think that that is clearly unlawful, and it will be challenged. But taking that aside for a moment, one shouldn't allow that to blur the overall support, not only from federations, including national federations, certainly my federation in England, clubs, players, the Players' Union, but also from agents for the overall proposal to bring back a proper regulation of football agents, to have a licensing system, to have a dispute resolution system, to have transparency, education, and so on. Those fundamental objectives that FIFA have put forward are widely supported by just about every football stakeholder that there is, because it is understood now quite properly that, like them or not, football agents play a key role in the transfer market, which is the most important commercial activity that most football clubs ever engage within. And they're not going to go away. And that means they need to be properly regulated. And that's the lesson we have all learned since 2015. But the prohibition of third-party ownership was not the opposite side of the same coin. It was really the same thing. It was simply a move away from regulation by FIFA, no doubt for very good and understandable reasons, because many argued that rather than have an outright ban on third-party ownership, the more sensible thing to do would be to properly regulate it, because, like agents, it was viewed by many, and is still viewed by many, as, to use a phrase, and I'm not trying to be pejorative, but as perhaps a necessary evil of the football transfer market. And so if it exists and if it actually assists football, if that's the view you take, it needs to be properly regulated. Regulating it is difficult, and regulating football agents was difficult. Administratively, cost-wise, just simply doing it is very difficult. And perhaps that's the reason FIFA stepped aside in 2015. But in now re-regulating agents in the way they are proposing, and having the clearinghouse that they are proposing, FIFA is now taking on an enormous new burden of regulation. And so it seems to me that it's an appropriate time to ask the question, should we look at regulating third-party ownership rather than the outright ban? And so we therefore need to go back to the argument that many of us had before about what are the benefits and what are the concerns or pitfalls of third-party ownership, because there's no point in regulating it if we all agree it shouldn't exist. In terms of the benefits, I think those are obvious and incontrovertible. No, there is no doubt that clubs can benefit from third-party ownership if it is properly regulated. I don't know how it is in Spain, although I do know about the impact of the financial crash in Spain on football clubs. But I do know in England, where we've had a number of football clubs who have had major problems with debt, that borrowing money is very difficult from financial institutions. And one of the reasons borrowing money is very difficult is because often the only or the greatest security a club can offer in return for a loan is security over their ground, their stadium. And the problem with that is, first of all, you can only mortgage it once, usually. And many clubs are now selling their stadium and leasing it back for various financial reasons. And you can only do that once. But the other problem is lenders do not like borrowing money against a football stadium, because if the club doesn't pay the money back, the lenders don't want to be in a position to try and take the ground and sell it. Not only would such a step be very unpopular, but also local authorities would usually prevent it from happening by planning permission and change of use permission. So it's very difficult for clubs to use their stadium or their ground now to borrow money. And what is the greatest resources that many clubs have? It is these players and their future transfer values. So it is obvious that that is an economic resource that would be useful for clubs, struggling clubs, to borrow money against and to be able to better compete. The second arguable benefit is the potential opportunities for players, particularly from lower league clubs or poorer countries, who might not otherwise have sufficient investment in them to take them to a different market in order for them to progress. And typically, the model, so the proponents of it argue, of moving from Latin America players to Europe through third-party investment has assisted a number of players to make that step. And again, arguably, and I have not done an analysis of how this has actually worked, but surely if properly regulated it could work. That money, some of that money can go back to academies and clubs in those lower leagues or poorer areas. The concerns about third-party ownership, the one that I have never accepted, and I've never had anyone argue with me and persuaded me. So if there is someone here who believes this, please do try and persuade me, because I may have missed something. This idea of modern slavery, I just cannot understand or accept that. The reason I can't understand and accept that is football players are traded by their clubs, by their employers. That is modern slavery, if you want to use that emotional terminology. If you want to oppose modern slavery, if that's what you mean, then you have to oppose the entire transfer market. That is the only consistent position. Once you accept that a football club has the right to buy and sell a football player, then the fact that a third party may have an interest in that doesn't make something that wasn't slavery into slavery. The second point is that third-party investors may threaten contractual stability. Now, that's why it's useful to remember the objectives in the Seraing case. That's clearly a problem, as are the threats of integrity, the threats to integrity of football, where you have a third-party owner, for instance, having players in one team and another team in the same competition and so on. And then even worse, money laundering, corruption, and various other things. However, all these things are surely dangers or risks that can be dealt with by proper regulation. I'll come on to the type of regulation perhaps we should suggest, but they are all things that could be dealt with by a system that regulated third-party ownership, and to not regulate it, but simply to prohibit, must surely in some respects make some of these things more likely. Certainly the last one on that list, because now anybody who is involved in third-party ownership, it's a bit like betting. Many of us are involved in betting cases in football. And the real problem with betting in sport usually comes from those markets in the world where gambling is completely illegal. Because if you're in a jurisdiction where gambling is completely illegal, then you are already a criminal when you are taking sports bets. And so you are more likely to be involved or turn a blind eye to corruption in other jurisdictions where gambling is lawful than you would be if you were regulated. So it's a bit like that argument. If you are a third-party owner now, you're already concealed. You're already keeping what you're doing secret. You already don't care about the regulations. And you're more open to those sorts of problems.
If I can maybe just mention one other point just very briefly, Nick, which we were talking about actually on the coach on the way here, which was, look, speaking from a football fan's perspective as well, one of the areas that I think is underplayed in terms of some of the advantages is competitive balance. Now, there might be lots of different ways to be able to find better competitive balance within a league, across different leagues and teams playing across teams across different competitions. But I think one of the benefits that a lot of teams, even for example in the non-top 5 leagues across Europe, espoused for a number of years, was that effectively they have been under a competitive disadvantage for a significant period of time. They don't have the TV markets, the large TV markets that a lot of leagues have. They don't necessarily have the same commercial opportunities potentially too. And as a result, if one of their competitive advantages is to be able to effectively partner up with entities in order to effectively mitigate risk and to be able to effectively underwrite particular expenditure, might that be a good way of being able to provide better competitive balance across a variety of different leagues? So I think that's an important point just to bear in mind. Now, again, I listened to the fascinating debate yesterday about FIFA resource and National Association resource. I completely agree with that. I mean, I think to be able to, and Nick will talk about it in a short amount of time, to be able to regulate a market as big as TPI and TPO, it would probably be a monumental task. But I think maybe there is a time to reopen the discussion, because I think there are a number of advantages, and my personal view as well is that a lot of the disadvantages to a degree can be mitigated through regulation.
And I'm not going to go into the detail in the time, but I would have thought if you do start to look at regulation as opposed to prohibition, the key things that you would need in order to support the objectives of integrity, contractual stability, transparency, and so on are these. First of all, I think you should consider making investors participants in the same way as agents would be, so that they would have to apply and be subject to the discipline and jurisdiction of FIFA. Because one of the worst things is those cases that we all are involved with, where the real villain is the one who is not regulated, but it's the club or the player or the agent or whoever else who is, because they are regulated, the one who measures can be taken against. So they ought to be perhaps even licensed, and there ought to be a fit and proper person test for an investor if you were going to regulate it. So to bring them under the jurisdiction. The second issue, and it's related to the first, is transparency. You can't prevent third-party influence and the various risks that are involved that we have looked at without having full transparency and accountability, and knowing exactly who the investors are. And if an investor says, well, I'm sorry, I want to keep my shareholders secret and so on, then, well, you're not allowed to invest in football. Too bad. You need transparency to make sure, for example, the same shareholders don't have an interest in different clubs within the same competition. And then there are limits on the number of clubs that an investor may be able to, particularly in the same competition, that an investor may be able to invest in, or the amount of investment, exactly what those limits are, would need to be decided. But clearly that's one of the things you could look at. And you would have to keep and maintain and police the prohibition on influence. So it seems to me those are the basic 4 things you would look at. And as Daniel said, this may be an impossible task, and it may well be an unwelcome task. If the majority of football still genuinely believe, for good reason, that third-party ownership is an evil and is not helpful to football, then it's not worth considering this. But if there are a number of us in football who think it could, if properly regulated, be something that could be of use to players and clubs rather than a danger or a risk, then surely it's something we should at least think about and start thinking about ways to regulate it. And I just wanted to say another reason why that's perhaps the case is because of what's happened since the ban. And there are 2 things that have been spoken about. One is so-called bridge transfers that some of you will be familiar with, the idea that a club will buy players simply for trading purposes and then loan them out to other clubs and never play those players, and then profit from their sale after they've been exposed by being loaned out to other clubs. I'm currently involved acting for a club called Deportivo Maldonado in Uruguay, many of you may know of, in a case in CAS against Paranese in Brazil about this issue, because the other side claim that that's what Deportivo have done. The problem so far with that argument is that there is nothing wrong with a club economically profiting from selling its players. It's what clubs do all the time, and the club is not a third party. So FIFA has recently, I understand at the recent stakeholders meeting a couple of days ago, decided to ban bridge transfers going forward, or to prohibit them in some way. I haven't yet seen the wording of the key issue which will be problematic, of what is the definition of a bridge transfer and how you prove a transfer is perhaps done in bad faith, and what does bad faith even mean in this situation? Because surely it can't be a transfer that is done for solely economic reasons, because I know a number of proper football clubs at every level of English football that will often make a transfer for solely economic reasons because they have no choice. So there's the issue of bridge transfers and how will that be regulated in the future. And then the other area that is an area of concern, I think, is multi-club ownership. So it's very common in England for the Premier League clubs and even some of the Championship clubs to own other football clubs within Europe or within Africa or within other jurisdictions, or for their owners to own clubs in different jurisdictions. There are obvious problems with that in terms of integrity, which can be dealt with by regulation to make sure those clubs are not within the same competition and so on and so forth. But those integrity problems are not as simple as that. Daniel made the point about financial fair play. Imagine you are a club take the example because I'm from England, in the English Championship, the second division of English football, where you have some very big, strong clubs that are economically like Premier League clubs, clubs like Leeds United and so on. Imagine you're a club in that division and you're heavily restrained by financial fair play rules, which are much stronger in that league than they are in the Premier League. You're heavily restrained from spending. But your owners own a club in Belgium or Italy or wherever else, and that club can then loan its players to your club, and you can play them, but the owners are paying A, the transfer fees, and B, perhaps a proportion of their wages through another club, and therefore you get a competitive advantage in competing with clubs within your league. So there are all sorts of other problems which ultimately, what all this boils down to, what all the entire justification and purpose of what we all care most about when we talk about regulation in football is integrity and, if possible, the creation of a fair playing field. The dangers are still there once you've banned third-party ownership. The dangers of agents having players in a number of teams within the same competition at the same time and having an interest in undermining contractual stability, they are all there once you've banned third-party ownership. And so perhaps the real struggle now is to come up with a form of regulation that isn't simply banning something, but working out how to regulate it in such a respect that maintains those interests of integrity and competitive balance and so on.
We have 8 minutes to spare.
Okay, so do we have any questions or debates or arguments? Yes.
I thought there might be a few questions.
Any question, alguna pregunta por aquí? En el pasillo central. Por ahí.
Oh, someone else has got there first.
Good morning. I have a question. Yesterday we heard that third-party funding and litigation funding can be in the future of sport arbitration because of its predictability. I was wondering if you think that this is something that should be taken into account in the new regulation on third-party ownership and third-party influence, and if you see this also as a big opportunity for the sport industry, especially in relation to legal aid, and how do you see that this could be problematic or not?
That's a really interesting question. It doesn't strike me immediately as analogous, because litigation funding doesn't immediately pose the same dangers to, or the same risks to, the integrity of the competition, contractual stability and so on. But you can then begin to think of examples where it might do. If the litigation is about whether a player's contract subsists with a club and there is a potential transfer and so on. So it's a bit like the worldwide ban on betting is no longer limited, as I'm sure you all know, to betting on football. It's also betting on football transfers and other football-related matters. And so if litigation funding is, third-party litigation funding is linked to something which may have an impact or effect on the competition, then you're right, it needs to be looked at in terms of regulation or even prohibition. On the other hand, the other part of your question, yes, I do think and hope, especially for all of us lawyers, but also for all of our clients, that we can develop ways to use litigation funding creatively in order to allow those who don't have the same deep pockets as some of our clients to properly and fairly litigate their disputes. Did you want to say something? No.
That I should narrow down the question, because what I see as a problem for litigation funding is that most of the time in sport arbitration, you are requesting no monetary relief. You want to be admitted to a competition, you want just the suspension to be withdrawn. So there is not a direct interest for litigation funder to invest because they don't have a direct monetary relief on which they can take a percentage. So then the percentage could be 20% of all your future salary, 20% on all your future transfer, and this kind of percentage that the litigation funder can take. Because I think that the reason why we don't see litigation funders investing in football, or sorry, investing in sport arbitration, is because most of the time they don't see the monetary relief. But then here the issue is that there are monetary relief which is not direct but are indirect. So that's sorry.
No, thank you. I understand the question then. And in that case, it would be clearly a prohibition of the rules. It would clearly be a breach of the rules, a breach of the prohibition for a club to give a percentage of a future transfer value to a litigation funder. Because that would be a third-party interest. So that cannot be allowed now. But the question you raise is a good one. It's the same reason as why I say clubs would have some benefit from a regulated system because of the difficulty of borrowing money, and here because of the difficulty of having litigation funding that's just linked to the success or failure of a case as opposed to a greater asset the club has. I think there was a question here as well.
Yeah, hi. Nick, Daniel, thank you for the brightening presentation. I have one question regarding the player's due for his future transfer fee. Is there any limit on that? Can a player agree with his club with no salary, but 100% of his future transfer fee? Because in that aspect, there will be many clubs interested in such deal. That's my first question. And the second one is that, Nick, I get your position about the slavery issue. I feel the same. I don't think it's slavery. But on the other hand, during my career, I had many interesting cases, match fixing, financial fair play, usual contractual stuff. But one very interesting one was related to third-party ownership before it has been banned. And in that issue, there was this strange transfer scheme which went on. There was a very small club with a very usual ordinary player who used to get 200,000 K per year, euros that is. And he has been transferred to a big club in a big country, Big Five, one of the Big Five. All of a sudden, he went there, but not even the technical director, not even his teammates knew about this guy. He stayed there for only 26 hours and then transferred to some other country, and with, I think, 8 million euros in return. So you see, when you talk about third-party ownership, and when you say that's not slavery, I can agree on that with you. But these kind of issues were very common with certain groups and certain schemes. So that's my concern over here. What's your take on it?
Well, in relation to your first question, no, there is no limit on the percentage in the regulations, and I can't see anywhere else where there is a limit on the percentage. So theoretically, a player could insist on 100%. What I don't think works is the idea that a player could not be paid a salary, because then it wouldn't be a professional contract, and so that wouldn't work. He needs to be paid a salary. And in relation to your second question, yes, that's right. But what I was talking about those other things that maybe have filled the gap since third-party ownership, like bridge transfers or multi-club ownerships, I think the same issues arise there as the example you have given, or potentially.
And just very briefly on the first point as well, I mean, usually the type of percentages that I've seen, at least in the summer, have been between 5 and 15 to 20 usually, is because ultimately also, but it's the same type of analogy, the club has to be incentivized to sell the player, is the truth. Now, if, for example, a player has 80 or 90% of his transfer value, the club may just decide that it's not in their better interest to sell the player, and
you get a release clause.
And you get a release clause otherwise. But all of that has to be in the mix.
Only 2 questions more at the back.
Yeah, Nick, I'm going to speak in Spanish.
I need to get excuse me,
They're not them.
Okay,
This
thank
isn't
you.
it. I need to get the... Has anyone
Yeah.
got a translation thing?
Okay,
Sorry, my...
congratulations.
Thank you.
You can tell me what he says.
Yo confieso que comparto todo lo que dijiste, sobre todo
no,
en el...
it's- Hold on, sorry.
Yes,
I've got
okay.
it in Spanish.
I did one.
Does anyone know how to work this?
Yeah, you just change the
This
channel.
into-
Number 2. It's okay.
Thank you. Hello? Sorry, go on. Forgive me.
Okay, thank you. Decía que confieso que comparto contigo todo lo que decías, sobre todo la cuestión de la esclavitud. Cuando lo pensé, yo lo pensé mucho, y realmente después me convencí que se trataba un poco de, no de la persona, sino de su talento, de uno de los elementos que él tiene, que estamos hablando del jugador, y de una transferencia y en sí un beneficio de esa transferencia de talento. Es un poco lo que liberó mi culpa, pero a ver, y en este tema, y sobre todo en Sudamérica, donde se sufre mucho la inclemencia de una inestabilidad económica, ir a los bancos es muy difícil, y yo en algún momento pensé que este negocio también podía ser un negocio lícito, tal como el de la bolsa, si se llega, porque se podía poner un valor en función de una futura transferencia y un crecimiento económico del negocio. Y es cierto, también comparto el tema del límite. En algún momento se habló que el límite total podía ser de un 70% en general. En mi país confieso que se ha llegado a vender hasta un 110% en alguna transferencia de jugador internacional, que es algo cómico. Yo pensaba en ese límite, porque creo que el club debe guardar una parte, y no sé qué opinas también de un límite temporal, porque hay muchas veces que los clubes se pueden sentir presionados por ese tercero en una venta urgente, rápida o cuando necesite, y plasmar de esa manera una cláusula resolutoria, pactando un tiempo que, si no se realiza la transferencia, el club pueda devolver ese dinero con un interés poco más que un bancario o un interés negociado, ¿no?
Yes, just for Daniel's benefit also, the questioner made a number of very good points and then asked a question about a limit on, as I understand it, the percentage a lender could take if they were a third-party investor. And in my view, a sensible limit would be around 20%. I mean, maybe a bit more, maybe a bit less, but I think where a club still has the overwhelming majority benefit from the sale, and stepping back from that, of course, you have to remember that many clubs have got, sell-on clauses and so on, so they might already be giving a substantial percentage away. But I kind of look at it, a lot of the contracts I've seen and had disputes about in England where there are sell-on clauses, a sell-on clause of 20% isn't that unusual. It's not that disproportionate. A sell-on clause of 50%, it kind of binds the club, doesn't it? And I think the same approach, although there's no limit there and it's to do with the contractual negotiation, if you did have regulated TPO, I think around 20-25% is a fair and workable limit.
The query I just had very briefly as well, just to add to that, which is just something to bear in mind, which is your last point, Nick, on whether obviously influence and the ability to be able to influence performance of the club in their transfer dealings would obviously still have to be prohibited, and there's a raft of cases on that. My query there potentially is if actually the third-party entity cannot have any influence over the sale, over the potential ability for clubs to be able to accept offers, there is a much higher risk for that third party in actually loaning or effectively forward funding that money, which means actually the cost of that money may increase significantly because the risk is that the player never transfers, he goes on a free transfer, or the club decide not to accept the amount. So I think ultimately the point on regulation also is a practical point, which is fine, maybe we can regulate it again. But if all of those contracts have to be uploaded to TMS, if necessary, if all of those contracts are then are audited accordingly to make sure that they don't have those type of influence clauses, then actually I think there might be a dearth of companies willing to finance third-party investment in the first place because of the risk of no transfer in the future seasons.
Could be, and it's obviously there should be some economic analysis taken before any new decision is made to see whether or not there is a market for it. Absolutely.
The last question.
Is this in?
Microphone.
There we go.
No.
Hi, Nick.
Sean, so it's in English, yeah?
Oh, yeah. There you go, you're lucky. Thank you both for the excellent presentation, very thought-provoking. Respectfully, obviously you're talking about the dispute end of things, and obviously we heard the excellent presentation from Ulrich yesterday and the effect of anchoring. But if, so you're anchoring to the issue once there's a problem, once there's a lack of something or there's an opportunity for something. Are what you're describing the reaction to a lack of access to capital as the fundamental issue? And if so, given that the vast amounts of capital that there are within the football industry globally, that maybe there's an alternative way to take a step back and look at setting up some sort of body that could give clubs, leagues, conditional, like we have in the UK around sports governance, on meeting a number of factors, access to capital, so it doesn't create an opportunity for some unscrupulous third-party investors or people willing to manipulate the players or clubs or leagues to fill that void. Thank you.
I'll just quickly say, I think as a holistic approach, I completely agree. The question is, as always, it's the same with regulating, where does the resource happen? If it's the same as providing capital, where ultimately does the capital come from in the first place? Usually in our capitalist society, it has to be, as you said, anchored in a particular asset or a particular security or in a particular manner. And I agree. I think we are obviously talking about a very narrow regulation for a very narrow specific purpose. And if we're talking more widely about solidarity and the redistribution of monies more generally, or the ability to be able to find finance in different ways, I totally agree. I think almost that, in a way, is a much higher isolation point, which is if clubs or sporting federations or bodies need types of money to be able to finance particular projects, whatever they might be as well, then absolutely fine. I think in this case, what we are potentially saying or positing is, can there be an additional way to be able to finance in certain limited parameters? But I certainly agree with you, Sean, that if there are additional, more holistic 360 ways to be able to find finance in a different variety of manners, then that can only be a good thing.
But also, you've got the kind of socialism or capitalism debate here. And I was speaking to someone who used to be the CEO of NBA basketball in Europe the other night, and he was saying their system is socialism for the rich, and it works because they have a wage cap, they have a financial fair play cap. Clubs are allowed to make money, but only a certain amount, and if they make more money than that amount, it gets redistributed to all of the other clubs. And that system works, and it works to a certain extent. It works in some sports, it's competitive, and there are lots of good arguments for it. I think the biggest problem is it's difficult for FIFA to regulate third-party ownership, but imagine FIFA trying to have a worldwide redistributive football scheme of that type. I just don't think it's possible, but certainly it is worth looking into what you can do within the current system.
Thank you, Nick. Thank you, Daniel.